Hello, we're at part 5 now. This is the motion for reconsideration of Judge Allen's October 27th, 2009 order. It has already been established that plaintiff/counterclaim defendant Irene Perry was given a preponderance of evidence that defendant/plaintiff Patricia Gray was one of the owners of Mrs. Perry's rental unit. At the rule returnable hearing, it was put on the record that Lewis Starkman Company sent Miss Perry letters dated April 11th, 2007 and May 20th, 2007. Both letters are titled Notice of Change of Lease, and in both letters Miss Perry is advised that as of March 1st, 2007, there will be a new management company for the property that she rents. The letters stated that the new management company consisted of Ingrid Johnson, Gwendolyn Jackson, and Patricia Jackson Gray, and one of the letters had Mrs. Gray's telephone number. July 28, 2007, Mrs. Gray sent Miss Perry a letter advising her of the strained relationship that existed between defendant/plaintiff Patricia Gray and defendant Ingrid Johnson, with a copy of the front page of the deed evidencing Mrs. Gray's ownership. The letter also included a notice to Miss Perry to start making 1/3 of her monthly rental payments directly to Mrs. Gray. Plaintiff/counterclaim defendant Irene Perry refused to make rental payments to Mrs. Gray. In order to maintain an ejectment action, the landlord must be out of possession at the time the instant complaint was filed. That was the case. Ms. Perry's counsel stated that she no longer is in the property. It is my understanding that she has turned the keys over to Ingrid Johnson, who refuses to communicate with Mrs. Gray. An affidavit from Ms. Perry indicating that she is no longer in the property would be satisfactory. The remaining new matter counts should be permitted to proceed. Defendant/plaintiff Patricia Gray sufficiently pled and established the elements necessary for the new matter counterclaim counts against Mrs. Perry in the amended joinder complaint and new matter counterclaim. Plaintiff defendant Perry did not address these elements in any of her pleadings or at the rule returnable hearing October 27th, 2009. B. New matter counterclaim loss of rental income of conversion. Conversion is an intentional interference with a plaintiff's right to use or possess his or her personal property. Chrysler Credit Corporation versus Smith, 434 PA Super, 429, Pinpoint 434, second citation 643, Atlantic 2nd edition 1098, Pinpoint 1100, 1994. A plaintiff has a cause of action in conversion if he or she had actual or constructive possession of a chattel or an immediate right to possession of a chattel at the time of the alleged conversion. Citing Eisenhower versus Clock Towers Association, 399 PA Super, 238, Pinpoint 243, second citation 582, Atlantic 2nd edition 33, Pinpoint at 36, 1990. A named loss payee on a contract for insurance has an action for conversion against the insurer if the proceeds are wrongfully distributed. At 435, 643, Atlantic 2nd edition at 1101. Among the ways a person may incur liability for for conversion is by unreasonably withholding possession from one who has the right to it. Martin versus National Security Corporation, 437 PA 159, pinpoint at 165. Second citation, 262, Atlantic 2nd edition, 672, pinpoint at 675, 1970. Also citing Prosser, Torx, section 15, 2nd edition, 1955. In reviewing a claim for conversion, a court must focus not on a defendant's intent to commit a wrong, but rather its intent to exercise control over the chattel in question. McKeeman versus Core State Bank, N.A., 751, Atlantic, 2nd edition, 655, pinpoint at 659, PA Super, 2000. The averment set forth as a whole in the lawsuit by Mrs. Gray satisfied the Pennsylvania rules of civil procedure. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff/defendant Perry did not address these elements in any of her pleadings or at the rule returnable hearing October 27, 2009. C. New matter counterclaim, trespass to personal property. The tort of trespass to chattels in Pennsylvania is governed by Restatement 2nd of Torts, Section 217, Ways of Committing Trespass to Chattel, which provides, a trespass to a chattel may be committed by intentionally A. dispossessing another of the chattel, or B. using or intermeddling with a chattel in the possession of another. Pennsylvania courts have long recognized that the tort of trespass to chattel must be based upon some tangible form of property. See McKay versus Benjamin Franklin, R&H Company, 135 Atlantic 1st edition, 613, pinpoint at 614, 1927. In Norcraft versus Edward C. Michener, Associates, Inc., 466 Atlantic 2nd edition, 620, PA Super, 1983. It was concluded a tort based on interference with an individual's property right in a chattel, regardless of the nature of the chattel, presupposes the existence of that chattel. The action must therefore be limited to chattels of existing nature, i.e., those whose existence is ascertainable by some concrete proof. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff/defendant Perry did not address these elements in any of her pleadings or at the rule returnable hearing October 27, 2009.